Good morning to all of you. అందరికీ శుభోదయం. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయి బాబు శంకర్. ఈ వీడియోలో మనం రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్ ఆల్రెడీ లా ఆఫ్ థాట్స్ స్టూడెంట్స్కి ఐ ఇన్ఫార్మ్డ్ ది రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్ ఈవెన్ దో ఇట్ కమ్స్ అండర్ the law of crimes. Please remember, right of private defense must be strictly, please remember, preventive, not punitive. Realistic, timely, equal, proportionately. So many words I have told you. Please remember, recollect them once again. So it is there to prevent yourself from further crime. Not an act of retribution. నాట్ ప్యూనిటివ్ యాక్షన్. ప్యూనిటివ్ అంటే ఏంటి? ఎవడో కుర్రాడు నిన్ను కొట్టాడని మీ గ్యాంగ్ అంతా తీసుకెళ్ళి రెండో రోజు వాడిని కొడితే ఇట్స్ నాట్ రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్. ఎక్సైజింగ్ ది యువర్ రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్. దిస్ ఈజ్ వాట్ ఈస్ స్టేటెడ్ బై ఆనరబుల్ 2 judges bench, Justice J.B. Pardiwala and R. Mahadevan, in the case of Rathish Kumar alias Babu. Rathish Kumar alias Babu versus the State of Kerala. Criminal Appeal number 1049 by 2018. This case was decided on 9th January 2025 by 2 judges bench, Supreme Court, in which Honorable Supreme Court of India observed that the right of private defense must be strictly preventive but not punitive or retributive. That's what I told you in the outlines. So the impending danger must be prevalent, must be present, must be anticipated, must be real, must be apparent. లేకుంటే కుదరదు. Clear? Right. Now we'll go to the case law. This is a murder case occurred in Edakkalam, పేరు చెప్పలేదు, of Kerala state. On 6/4/2007, actually there is a land dispute, border dispute between the accused and also the deceased person. Right? The accused present appellant Rathish Kumar alias Babu. Right? He and his father, they are having an agriculture farm, by the side of which the deceased was also having some agricultural land. There were disputes regarding the causeway, common way, and also the boundaries like that. On 6/4/2007, around 2:45 p.m., the deceased person was arranging some fencing to the land. కంచె కడుతూ ఉంటే actually father of Baburao, that is father of the appellant, he interfered, he chastised him. మరి ఏంద్రా నువ్వు మా దాంట్లోకి వచ్చి కడుతున్నావు అని చెప్పి he picked up a quarrel with him. So ఇద్దరి మధ్యన there was a verbal altercation which culminated into father called appellant. మనోడికి పిలిచాడు పక్కన ఎక్కడ ఉంటే. So he went there. Ultimately both of them caught hold of the deceased person. కంచె వేసేవాడిని పట్టుకున్నారు. And please remember, the appellant stabbed him thrice, as a result of which that person died. So case of 302 read with 34 IPC, registered promptly. The accused was arrested, and the case went for trial. Trial stage లోనే father was acquitted and this man was convicted under section 302 IPC. Conviction, this man went to the High Court for appeal, but the High Court dismissed the appeal. They did not allow. As such, the matter came to the Supreme Court. ఇక్కడ డిఫెన్స్ చూద్దాం, ఇంపార్టెంట్, మనం డిస్కస్ చేయాల్సిందే కాబట్టి. సో డిఫెన్స్, ది అడ్వకేట్ ఆన్ బిహాఫ్ ఆఫ్ ది appellant, that is Babu, he pleaded that no doubt he is innocent, but still if at all the honorable court thinks that the offense has been committed, it falls under exception 4 to section 300. That is, murder becomes culpable homicide. Exception 4 to section 300. Right. And also, please remember, So therefore, and why? Because it is not premeditated. It is due to sudden and grave provocation, and due to the provocation given by the other person by arranging the fencing, even though in spite of the request and advice by the elders and things like that. It was not premeditated. It was not pre-planned. Therefore, if at all conviction is to be given, it has to be given under section 304 part 1 of the Indian Penal Code. Second, he also pleaded exception 2 of 100 CPC. Please remember. So, A tried to act in execution of the right of private defense. So therefore, it is not an offense. Like that, normally every lawyer will try to defend his client like that. Right. Section 100 says, when the right of protection leads to killing a person, causing death of a person, please remember, the threat should reasonably cause apprehension that death will occur. అతను ఫెన్సింగ్ వేస్తున్నాడు. ఎందుకు వేస్తున్నావు అంటే he was unarmed. తగదబడ్డాడు చంపుతాడు, నీకు అనుమానం వస్తుందా? సెకండ్ పాయింట్, ఎక్సెస్ యూజ్ ఆఫ్ రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్లో ఓకే వాడిని ఆపుదామని వెళ్ళినప్పుడు ఏం చేయాలి? వాడిని పట్టుకున్నారు, ఓకే పట్టుకున్నాక పక్కన పడేయాలి. అంతేగాని హీ స్టాబ్డ్ హిమ్ థ్రైస్, అక్కడ ప్రివెంటివ్. ఒకసారి వాడు చంపుతాడు అనుకోండి, ఒకసారి చెప్తే సరిపోయేదిగా. 3 times he stabbed. That shows his unusual behavior, cruel behavior towards the deceased person. And other person, D, the deceased, he has no weapon and he was helpless. So therefore, he caused more harm than necessary by stabbing 3 times. That means the appellant took undue advantage and acted in an unusual manner as stated by the court. So therefore, it is not a case where the right of private defense exists. Basing on the reliance of the very good case law, Darshan Singh versus State of Punjab and another 2010. So the conviction is upheld. But anyway, since he has been in jail for the past 9 years, so a leverage is given to him that he can apply for remission in the sentence basing on his good behavior, and the state may consider the same. Anyway, the appeal is dismissed. So రైట్ ఆఫ్ ప్రిఫరెన్స్ మనం క్లెయిమ్ చేసేటప్పుడు చాలా జాగ్రత్తగా ఉండాలి, అయితే కష్టంగా ఉంటుంది. రైట్. సో విత్ దిస్ ఐఎమ్ కంక్లూడింగ్. థ్యాంక్ యూ వెరీ మచ్.